Okay. We are live and on the record.
Thank you. So good afternoon and welcome to the Appeals Court session for Thursday, September 9th, 2021. This is the fifth case of the day. The first four cases we actually heard in the courtroom, and we've moved on to the Zoom format for this argument. And as you know, we do the Zoom arguments pretty much the same way we do them in the courtroom, 15 minutes per side, no rebuttal. Although this is being live streamed, so it's on YouTube and people can see it. Just one other word of caution that when it's not your turn to speak, we ask you to be muted, but stay on the screen so we can make sure you're still here. But it's at the same time, we'd ask you to keep your reactions to a minimum because that can be distracting. So with that, I'm going to call this case, which is Commonwealth versus Salguero, 2020 P640, and we'll hear from Attorney Mannion.
Thank you. Good afternoon. May it please the court, Laura Mannion on behalf of Mr. Salguero. The sole issue before this court today is whether the motion judge abused his discretion in denying Mr. Salguero's motion without an evidentiary hearing. The standard, of course, for whether a case warrants an evidentiary hearing requires two things. It's a substantial issue. It needs to raise a substantial issue, which requires a serious issue, which we have no doubt with an ineffective assistance claim, and an adequate showing, not a perfect showing, not proving all of the issues, an adequate showing. The words substantial, adequate, they don't appear in the motion judge's decision. Didn't apply the standard for whether to have an evidentiary hearing. It appears the motion judge sort of jumped to the Padilla standard. He doesn't cite Padilla or Clark, however, but he does use some of the language that those cases require. So essentially what the motion judge did is he bypassed entirely the performance prong. And I wasn't going to go into the prongs. I know everyone on this panel is familiar with the Padilla standard. He bypassed completely the performance prong. Essentially, he said, I don't credit the defendant's affidavit. I do credit trial counsel's memorandum of understanding, essentially saying what he advised his client. Those actually were not contradictory, they were complementary. But at no point did the judge make any finding of whether that advice was accurate. It was essentially a question that was not in dispute. And that is the first thing that a judge has to do in determining whether a Padilla claim has been satisfied, whether the elements have been satisfied, is did the attorney provide correct advice?
So Attorney Mannion, let me ask you this question. Am I correct that your case in part hinges on whether or not assault and battery by means of a dangerous weapon, assault and battery on a family or household member, and threat to commit a crime are deportable offenses?
I disagree with that, Your Honor.
Okay.
It actually does not hinge on that. And I think that these are the wrong questions to be asking, and I'm happy to explain why. And it's because the issue is not simply what's the result going to be. There's a prejudice standard for sure, but we can't look at whether he's going to for sure get deported for these things as if he would if it was an aggravated felony, certainly. But what we have here is a situation in 2017 where this area of law was evolving. And I understand that that raises questions. Well, was it truly clear? And to be perfectly frank, Justice Neyman, I don't know. I don't know if it was truly clear. And I don't know for sure whether the US government would have attempted to seek Mr. Salguero's removal on those bases. They could have tried, but we don't know that they would have. And we certainly don't know that they would be successful.
So to stop you right there, the Padilla case itself says when the law with regard to immigration consequences, whether or not something is a deportable offense, is not succinct and straightforward, a criminal defense attorney need do no more than advise a non-citizen client that pending criminal charges may carry a risk of adverse immigration consequences.
That's correct. And the reason that we can't stop there in this case is because the advice that was given was half correct. The SJC uses these different terms. They use mandatory deportation for something that the statute, it's clear, right? It's in the INA, you know that it's a deportable offense. They use the term mandatory and inevitable when that plus no defenses, as in an aggravated felony. But here we have mandatory for the 209A and possible for the others. This motion was filed by one of the expert immigration attorneys in the Immigration Impact Unit. And the law, as my brother skillfully set out in his brief, is complicated. That doesn't mean that this attorney did not have a duty, though. And to be perfectly honest, Your Honor, I think the advice that the attorney should have given is the 209A violation, mandatory deportation. The others, I'm not sure. It's not clear. And then he can't stop there, because even in Padilla and the other cases, I think it's Henry from this court, when the law is not clear, you can advise your client, I'm not sure, you might want to talk to an immigration attorney. You can't do that when it's an aggravated felony, when it's certain. But the cautious advice actually in this case was not, it was overbroad, and it was not accurate that all of these were going to result in his deportation. And what trial counsel should have said was 209A is deportable. I'm not sure about these others. Let's consult an immigration attorney. And here is where the fact that this was a court-appointed case really comes into play. This stuff is complicated, but attorneys have this resource, the Immigration Impact Unit, which ADA Lee submitted some of their guides, and they are there. Their purpose is to provide one-on-one advice for a case in the individual circumstances. And we don't know for sure if trial counsel reached out to them. We can infer he didn't, because it would have been a conflict for attorney client to file the motion. However, there is an independent but related duty for an attorney under Marinho. And because we have this second way of establishing prejudice under Clark, this different plea, a separate duty. You can't stop by looking at the chart and saying, okay, this is mandatory, this is maybe. You have to go a step further, just like you can't just stop with this is a deportable offense when it's an aggravated felony. You have to
You have to go a step further. That step you're saying is to give a warning that you should consult an immigration attorney?
In this case, at a minimum.
So what authority supports that proposition you're making? Are you saying that this is an issue of first impression and we should develop a new rule?
No, Your Honor. I'm saying that when it's not clear, you don't give bad advice, essentially. This was misadvice. It's not the kind of affirmative misadvice we're used to. And this isn't a case where trial counsel just did nothing. The ineffective assistance term is so unfortunate that we have to use it. Trial counsel meant well. However, he stopped at the first stage, which is this a deportable or inadmissible? I'm sorry. Justice Neyman.
I'll stop you there. So let me just ask you two questions. The first is, your brother cites the Petit Homme case, 482 Mass 775, which says that ABDW qualifies as both a crime involving moral turpitude and a crime of violence for immigration purposes. You didn't address that in your reply brief. Do you agree with his analysis and his citation to that case for that proposition?
I did not address it because I was trying to bring the focus back to the question of whether a substantial issue was raised.
Can
This
you
is
answer my
not,
question now, though?
yes. I don't know. I don't know. And over the last 3 or 4 years, the law has been in flux. And as you can see from the dates of the cases that both the Commonwealth and I cite, it was not certain, but it was a live issue. And CPCS let us know that. We knew that there was extensive litigation going on about this, and that it is not true that the government still would have had to prove at that point. There had been no case law at that point.
Okay, as
saying-
of today, do you agree that under Petit Homme, ABDW qualifies as both a crime involving moral turpitude and a crime of violence for immigration purposes? That's what the case says.
I believe so, or at least it did the year that it came out. And I'm being perfectly frank, I don't know these things. Every time I do a post-conviction case, I reach out to the Immigration Impact Unit. I do the same thing that they offer to trial counsel, which is send us the query. We're going to tell you not only is this a deportable offense, but what might you be able to do about it, which in this case was, and I understand the issue, Justice Neyman, about whether it would have made a difference, but it would have made a difference because at the time, it was not for sure. Regardless of whether it was when Petit Homme was decided, regardless of whether it is now, it was not certain at the time, and it was patently incorrect, well-meaning but incorrect, to treat the two as if they were the same. As
Well,
if
the lawyers said likely 2 years before Petit Homme came out, and then, or at least maybe a year and a half before it came out, and then Petit Homme said not only likely, but definitely.
However,
Seems
before
like his advice was fairly prescient.
before Petit Homme, though, and 2 weeks, I believe, after Mr. Salguero's plea, it was held that it was not. It was not a crime of violence. And then we had Sessions v. DeMaya, and there was so much going on at the time that the IIU was telling attorneys, and this again could be addressed on remand, because maybe this is a mixed question of law and fact, right? Whether
Wasn't it a crime of involving moral turpitude before the plea?
what was, Your Honor? I'm sorry.
Assault and battery by means of a dangerous weapon?
Oh, yes, but he had no other crimes involving moral turpitude. I'm not sure where the Commonwealth gets that. Threats is a crime of moral turpitude. It's never been held to be. I have scanned queries and gone over the threats and said, I don't need to vacate this one because it's not a problem.
How about
So-
assault and battery on a family household member, which the Commonwealth asserts, I believe with some authority, excuse me, that is a deportable offense under the moral turpitude clause?
And this would have been his first crime involving moral turpitude. And he had been here for 26 years. So he actually wouldn't, the Commonwealth's argument about the crimes involving moral turpitude forming an independently deportable basis, that hinges on threats being a crime involving moral turpitude. And I just have no idea when or where that's ever been held. But again, we can't say for sure that it would have made a difference, just like with cancellation of removal, which this court has noted is a serious benefit to legal permanent residents to preserve that eligibility for cancellation of removal. We don't know if he's going to get cancellation, right? And it didn't work out so well for Mr. Salguero, who was not the most sympathetic defendant, but it was available. Just like the unavailable substantial ground of defense for prejudice, we don't know if the defendant's going to win the trial. but we knew that this 209A violation was going to result in removal proceedings, and we did not know, especially in 2017, and that is the time we look to. And I'm being perfectly honest, I still don't completely understand the divisible and all of this. It's extremely complicated, but we're not left to deal with it alone. And the Immigration Impact Unit would have given him advice that had he avoided those 209A violations at the time, he would, if he was even deportable at all, the government had to make the argument, as opposed to what happened is he would bear the burden for the cancellation of removal. But more importantly, it actually did turn out that for a few years there, it would have made a difference. And Attorney Klein represented him in immigration court, as you can see from the decision. And she wished desperately that he had gotten her advice, that trial counsel had gotten her advice before, and that this alternate plea had been worked out.
So what alternate plea was available? I mean, that's the Commonwealth says there's no alternate plea available. What's the evidence that there's prejudice in that regard?
As far as what could have been worked out that would have avoided deportability, assuming that, and I see my time is almost up, if I may answer.
Please.
Assuming that these were not deportable offenses, then that 9-month suspended could have been attached to the ABDW, the assault and battery household, and he could have gotten the 18 months probation. And if the Commonwealth saying it wasn't available because they're stubbornly insisting now it wasn't available, that's not the standard. Just like we don't take a defendant's statement that I wouldn't have pleaded guilty, that's a question that was never asked.
Aren't both, whatever you attach the probation sentence to, isn't that a conviction?
The probation sentence, it could have been, the probation sentence could have gone on to, that's a good question, Your Honor. I'm not entirely sure. I do think
a quaff is a conviction, right?
A quaff is a conviction.
So certainly certainly a guilty probation is a conviction. You'd have to get like pretrial probation for it not to be a conviction.
But he could have gotten them all. The 209A is the only one that needed to go away, and it wasn't the only charge. It's not like he was asking for pretrial. He would have been asking for pretrial probation and just to be let off the hook. And he wasn't asking for a reduction from a rape to an assault and battery. It was only that one charge that the Commonwealth would have hopefully wanted to treat him as they treat US citizens and have the actual consequences, the sentencing goals, the judge's sentencing saying that he needs to pay child support. The Commonwealth might have asked the victim what her position is, and we see that she testified on his behalf. All of these things create a reasonable probability that a different plea could have been negotiated.
Thank you.
Thank
Any
you.
other questions? Okay, well, thank you very much for your passionate argument and also very detailed in the law. We'll hear from the Commonwealth.
Thank you.
Good afternoon, may it please the court. My name is Chi Lee, Assistant District Attorney from Middlesex on behalf of Commonwealth. I'd like to first correct a mistake that in the Commonwealth's brief, Justice Neyman talked about the Presiding case. Commonwealth cited in page 32 and 35, claiming that Presiding note 12, saying ABDW qualifies as both a crime involving moral turpitude and domestic violence. That's incorrect. In note 12, the SJC said it was ADW that qualifies as both a CIMT and a crime of violence. However, that does not change the Commonwealth's analysis that a crime being a crime involving moral turpitude. In note 12, the SJC cited to a matter of J, which is a BIA case, talking about ADW as a CIMT that was decided in the 1950s. And in terms of being a crime of violence part of it, indeed, like 2 weeks after the plea in Windley, the First Circuit found that reckless ABDW is not a crime of violence. However, ABDW is divisible under Tavares in the First Circuit case. And intentional ABDW in Tavares was found to be a crime involving moral turpitude. and the defendant had a 2014 threat to commit a crime that he was committed to 90 days. I understand my sister saying she's not sure, there's no authority to help one way or the other. The problem is in Padilla and Marinho, if the counsel is not clear about the immigration consequences and there's a likelihood that a person can be deported, the duty is to advise that a defendant may face deportation, and exactly what happened here. In terms of the sole issue my sister talked about, the judge denied the motion without a hearing. The judge declined to credit the defendant's self-serving affidavit. This court's unpublished opinion in 2020, COMMONWEALTH v. Torres, cited in COMMONWEALTH's brief in page 23. This court in the panel upheld the denial of motions for new trial without a hearing because the judge declined to credit the defendant's affidavit. And in COMMONWEALTH v. SAP, cited in COMMONWEALTH's brief, page 44, the motion judge similarly denied a motion without a hearing because the defendant did not claim that he would have insisted on going to trial, which is exactly what happened here. The defendant.
Let me slow you down for a second.
Yes.
The Tavares case you spoke of earlier, did that case analyze the issue of the divisibility of assault and battery by means of a dangerous weapon in the context of deportability or immigration consequences?
No, Your Honor. It was a separate contact. I believe it was under the ACCA context.
The ACC. So have we looked to the Armed Career Criminal Act in the past to determine whether or not the same analysis applies in the context of deportation or immigration consequence cases?
I don't believe so. I don't believe that has happened in Massachusetts. However, it's a question of federal law, and this court should follow whether a state conviction falls under a federal deportation category under the federal law. And in this case, it would be the First Circuit jurisdiction. And I understand that there's no court has found in immigration context where the ABW or any other crime in this case was a deportable offense or whether it's a crime of violence. What an attorney, a criminal defense attorney should do is to take these laws and find a proper way and advise the clients properly. In this case, the VRO, the first docket, which is separate from the second docket, is very clear the defendant would be deported and he was advised so. So on that docket alone, there's no prejudice and there's no misperformance. And for the second case, I disagree with my sister saying this case is the first CIMT that's incorrect. In 2014, where the defendant was convicted of threat to commit a crime and was sentenced to 90 days committed. Massachusetts threat requires a transmission of intentional means to inflict harm. And CPCS, where my sister relied heavily on the Immigration Impact Unit, issued this guide was saying to designate threat to commit a crime as a crime involving moral turpitude. And a reasonable, fallible attorney would follow a specialized unit that supervises all public counsel in Massachusetts. And the advice is consistent with what the unit had provided. And that's
you're saying that the CPCS guidelines advise that threat to commit a crime is an offense that constitutes a crime of moral turpitude or involves moral turpitude, correct?
Yes, it says likely. It does not say for sure, but it's likely.
And your sister has also said, but there's no Massachusetts case that has officially held that. Do you agree with that as well?
Yes, and there's no federal case that's held on that either. And if that's the case, a counsel will have to go through the elements of CIMT and the threat to commit a crime, which shows there was an intentional transmission of the infliction of harm, that intent is a vicious mind that would qualify as a CIMT in this case. So for that matter, any CIMT in the second docket would render the defendant deportable. That could be the ABW, that could be the threat, that could be the AB family. I want to address specifically about the AB family being a domestic violence. I understand my sister is saying these CPCS guides manuals should have been submitted before the motion judge. However, the Commonwealth did not argue that the plea counsel rely on these guides, and it doesn't matter how plea counsel reached his advice. The question is whether the advice was proper. And the JC in the Renanco and in Clark has surveyed these ABA standard CPCS manuals to determine what's a what an ordinary fallible attorney would have been expected to perform. This shows a legal question to hold the standards for criminal defense attorneys. And advice from the CPCS in 2017 about the case note, where they advise attorney to say A and B or ABPO in that specific case will qualify as a crime of violence. So if attorney follows that advice, in this case, AB family would also qualify as a crime of violence, and that would then qualify as a crime of domestic violence, an independent ground for deportation. All of these claims, all of these arguments to show two points. One is the defendant received proper advice on both dockets. Second, there's no reasonable alternative plea, because if the defendant were to receive a better plea to avoid immigration consequences, the Commonwealth would have to dismiss or PTP every single case. That is not possible. And even if we treat the only thing that could find the defendant deportable is the VRO docket, the Commonwealth, a reasonable analysis of all these scenarios would not enable someone to find a reasonable plea is possible, because the VRO was a separate incident from the second docket. There's no reason for the Commonwealth to give someone a PTP or dismissal on the VRO docket, which is a separate incident where the defendant had a significant domestic violence history against the same victim. And regardless of these claims, the key point is the defendant failed to say that he would insist on going to trial, which is a requirement to bring a Padilla claim. And this court, in the SAP, a panel of this court in 2013, has held that if a defendant failed to claim that he would have insisted on going to trial if given proper advice, a motion judge is entitled to deny the motion without a hearing. And that's exactly what happened in this case. If the claims were, if all these claims, if the Commonwealth's argument prevailed, that means the motion judge properly denied the motion, whether there's a hearing or not. And in this case, an evidentiary hearing would not provide anything else. For the performance crowd, there was an MOU that's created between the defendant and trial counsel and plea counsel. That's a contemporaneous record allowed this court and the motion judge to determine as a matter of law whether the defendant received proper advice.
Can I ask a very basic question? You know, the normal rule is that we defer to the credibility determinations of the trial judge or the motion judge, if the motion judge or the trial judge, or because here we have the motion judge as the plea judge. But do we still defer to the credibility determinations if they're made entirely on the papers?
Yes, Your Honor, because he was the plea judge who would have known the circumstances of the plea when that happened, especially when plea counsel was the one standing in front of the plea judge and then provided this contemporaneous record. I guess in terms of the performance part, this court does not have to accept whether the defendant was aptly represented by counsel, because this court could look at the MOU and determine whether the advice was proper, if that addressed the question.
Yeah, and I had a follow-up question too, right? It's we don't have the transcript of the plea colloquy, do we?
No. But the judge did indicate in his ruling that he considered a plea colloquy.
Right.
If there are no further questions, the Commonwealth on brief.
Seeing none, thank you, Attorney Lee. Thank you both for your arguments, and we'll take the case under advisement. And that will conclude our session for today.
Thank you.
We actually don't need to set a Zoom to conferences.
Are we still streaming?
Huh? Eric, say again.
I think we're still streaming.
Ah,